Mr. Telles, sir, can you hear and understand the interpreter?
Señor Telles, ¿puede usted escuchar y entender a la intérprete? Yes.
This is your first appearance hearing.
Esta es su comparecencia inicial.
I'm not here to take a plea in your case,
Yo no estoy acá para aceptar una declaración a cargos en su caso,
nor to have a trial of your case.
ni para tener un juicio en su caso.
I'm here to tell you what you've been charged, your charges,
Yo estoy acá para decir de lo que se le acusa, decirle cuáles son sus cargos,
to tell you your bond, if any,
decirle si tiene fianza, de cuánto sería,
and to set further court dates.
y para darle las próximas cortes.
Mr. Telles, sir, you've been charged with one count of burglary of a residential, burglary of a residence.
Señor Telles, a usted se le acusa de entrada ilegal con fines ilícitos a una residencia.
You've also been charged with theft of a motor vehicle.
También se le acusa de hurto de vehículo de motor.
I am going to deny bond on both of these offenses.
Y yo le voy a negar la fianza en cada uno de estos delitos.
You're going to have a preliminary hearing date set for June 27th at 8:30 in the morning.
Usted va a tener una audiencia preliminar programada para el día 27 de junio a las 8:30 de la mañana.
You're going to also have a bond hearing date set for July 1st.
Usted también va a tener una audiencia para pedir o para solicitar fianza para el día 1 de julio.
It's my duty to inform you of certain rights.
Es mi trabajo informarle cuáles son sus derechos.
You have the right to the presumption of innocence.
Usted tiene el derecho a la presunción de inocencia.
You have the right to indictment by a grand jury for most felonies or by accusation for misdemeanors.
Usted tiene el derecho a que el gran jurado le formule una acusación formal en la mayoría de los delitos graves o que se le formule una acusación por si es un delito menor.
You have the right to a speedy and public trial by jury.
Tiene el derecho de tener un juicio público, rápido y por jurado.
You have the right to see, hear, and question witnesses who are called to testify against you.
Usted tiene el derecho de ver, escuchar y contrainterrogar a cualquier testigo que sea citado a testificar en su contra.
You have the right to compel the attendance of witnesses to testify on your behalf.
Usted tiene el derecho de exigir a que los testigos comparezcan para que testifiquen a su favor.
You have the right to testify on your own behalf or offer evidence in your own defense.
Usted tiene el derecho de testificar a su favor y de presentar pruebas para ser usadas en su defensa.
You also have the right to an attorney. If you cannot afford an attorney, one can be appointed to represent you.
Usted también tiene el derecho de tener un abogado y si usted no pudiera contratarse su propio abogado, usted tiene el derecho de que le nombren uno para que lo represente.
Would you like for me to make a determination as to whether you qualify for the appointment of a lawyer?
¿Quiere usted que yo determine si usted califica para que se le nombre un abogado?
Are you currently working, sir?
Actualmente, ¿está usted trabajando, señor?
No trabajo.
No le escuché.
No trabajo.
¿Me dijo que sí trabaja?
Es que
No le estoy escuchando. Me dijo que sí trabaja o que no trabaja.
trabajo.
I do work.
Approximately how much do you make per hour?
Aproximadamente, ¿cuánto gana usted por hora?
La verdad no me acuerdo.
The truth is that I don't remember.
Can you give me a ballpark?
¿Me podría usted dar una idea?
No se puede dar una idea, ¿entiendes? No puede dar una idea yo.
¿No le puede dar una idea?
No.
I cannot give you a ballpark.
How much do you make per week?
¿Cuánto gana usted por semana?
Pues, gano 250 al día.
I make 250 per day.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you.
Usted sí califica, señor, y le voy a nombrar un abogado para que lo represente.
Okay.
Do you have any questions of me?
¿Tiene usted alguna pregunta para mí?
No, esta no.
No, not right now.
Okay, sir, you're free to go back.
Ok, señor, puede retirarse.
That was the only person I was told that we have today. I'm going to make a check. Do we have anyone else that needs the services of the interpreter?
No, Your Honor. No, Your
Okay. Okay. Thank you, Ms. Bermudez. Have a good day.
Thank you, Judge. You do as well.
Okay, let's switch over now to Mr. Rayner. Mr. Rayner, sir, you've been charged with 1 count of simple battery. The bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Courtney Yarbrough. Do you understand that?
Yes, sir.
Your preliminary hearing date, because this is a misdemeanor, is going to be set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. Do you have any questions of me?
No, sir.
Did you hear the rights that I explained to Mr. Tellis?
Yes, sir. I'm a former police officer. I'm aware of.
Okay. All right. Well, if you don't have any other questions, Mr. Rayner, you're going to be free to go back, okay?
Thank you, sir.
You're welcome.
Thank you.
Okay, let's see. I'm going to take the lawyer cases in alphabetical order. So that means Mr. Jacobs is going to be first on the male side. Raheem Jacobs. Or Raheem.
Here he is, Your Honor.
Okay. Mr. Mudine is here.
Sure.
Mr. Jacobs, I would normally speak to you directly. However, you've taken advantage of the opportunity to hire a lawyer, so I'm going to speak to your lawyer. But I must advise you that nothing you say here is private or privileged. So please don't say anything you would not want the whole world to know. Do you understand that, sir?
Yes, sir.
Okay. Mr. And I'm sorry, my eyes are going bad. It's Mubin.
Mubin, yes, sir. That's correct, Judge. And on the end.
Yeah, I keep trying to say Mudine. Okay,
Oh.
Mr. Mubin, your client is charged with 1 count of aggravated assault, 1 count of battery, and 1 count of cruelty to children in the 1st degree. I have denied bond on the aggravated assault charge and the cruelty to children in 1st degree charge. I've set a $5,000 bond on the battery charge. However, I will listen to you. Let me pull his criminal history back up. Because honestly, I can't recall if he's restricted or not. But while I'm doing that, I'll hear from you, sir, as relates to your client in the case. And bond.
Of course, Judge. I understand that the court's made its decision, but we want to inform the court about who's before you. He was a 36-year-old male. He has a family. Of course, we don't want to litigate this in this venue, Judge, but I think the facts are going to be on our side. The alleged victim in this case is his stepdaughter. She actually had a runaway previously. There's a statutory rape case in which she's the victim. She ran away a short time afterwards again. She was found at a Kroger, and there were allegations that were made. There were sexual allegations actually made against my client, and forensic interviews were done. They were all, and no sex charges were taken out. It was actually the road officer, which is kind of a confusing course of events. The road officer is the one that took out these charges. No weapon was found for the alleged ag assault, and we look forward to proving his innocence. Were this court to be able to hear bond, or were the judge to hear a bond, we'd ask for a bond amount of $10,000. We just ask that this be set as quickly as possible so we can move forward. As the court knows, and as my client knows, we've got very limited information at this time. Again, the facts are on our side. We just need that to come out, Judge.
The thing that caused me concern about this case was an allegation in the warrant that the juvenile victim was struck with a metal object. And I know I don't want you to put your case out here, but that's one of the things that I considered along with your client's criminal history. Go ahead.
And sorry, I didn't mean to cut the cord off. I could just speak to that, Judge. And that's another issue why it's a little bit frustrating that it was the road officer that did this. We reached out to the detective in this case, and the detective wouldn't speak to us, but there were no charges that the detective took out after the evaluation. We even spoke with, and I can say this as the officer of the court, we spoke with the DFACS worker, and she said that the detective told her, again, I know this hearsay twice removed, that there were so many inconsistencies that he didn't believe her. Honestly, I think that I never want to victim blame, but I believe she just wants to, and she said that she wants to be out of the house and does not want to be with her stepfather. There was no weapon ever recovered. There was no metal rod ever recovered. We've got pictures of the injuries. Those were not consistent in time. So it was likely something subsequent, Judge. And I believe the court has mentioned his criminal history. Is that right?
Yes, sir.
And that's something also, Your Honor, that I wanted to speak about. My client, he beat the odds. He went into custody for other charges, and he has made it out, and he's done well for 7 years. He's currently he's a supervisor in a construction company, and he worked himself from the bottom all the way to the top. And he's prepared his job that maybe a second before he gets out, and they value him so much, he's got that job waiting. He is a father to 2 children. His wife, who is the mother of the alleged victim in this case, she's just as confused. The DFACS investigation for the statutory rape was completed just a few weeks ago. The child was returned to the home. Now the DFACS plan is for the child to be returned again at the end of 30 days. She's with an aunt right now. And it's a tough situation for my client to be in, just because he has done so well. He literally beat the odds, and then this case has come along. And again, Judge, I don't want to litigate this, and we don't want to get into too many facts, but I think that we're happy to show our cards, and that there's no weapon. It's a deputy that made the arrest. We've got potential Brady material in the DFACS records that's going to come out. It's just a really, really tough situation that he's and he also, Judge, if I may, he actually turned himself in. As soon as he found out this was happening, police came to his house looking for him. He wasn't there. He got me on the phone, got me on board, turned himself in yesterday. So he wants to avail himself of these charges. I'm on board. We just, like any kind of bond in this case, to get him out as soon as possible so he can continue being a parent. No contact's not an issue. We've got no problems with that. It's just any attorney that's going to stand here on the side of the screen is going to make, they're going to argue and advocate for their clients. However, this in particular, based on the objective fact, is it's a little different, Judge. It's a little different. We just want this to move along quickly, have him out in a bond so we can see where the facts shake out.
Well, I'm listening to you. Because when I read the affidavit, the way the affidavit reads, it seems like this alleged incident took place in Kroger, but then there's nothing to indicate that it took place in Kroger.
No, sir. As Officer Gordon said, it never took place in Kroger. She ran away. She ran away a second time after her mother told her that that you can't do this, and ended up calling the police on the defendant for the alleged statutory rape. She ran away from home again, and she was just found out at Kroger. Her mother, Natalie, who is my client's wife, who was actually watching and wanted me to tell the court about how she supports him. She's the one that showed up to Kroger hoping to pick her daughter up. And then these allegations came out. And again, they were sexual allegations that were made. And then there was nothing happened further. We're a little bit surprised about how the forensic wasn't done first. None of that was done. Warrants were taken. The piece are kind of being picked up on the back end, and unfortunately at the expense of my client, Judge.
If I were to grant bond, where would your client stay?
Judge, he could go anywhere. Again, he's not a rich man, but again, he is started from the bottom, worked his way up. He would go home with his wife. Currently, the child is not there. His stepdaughter is not present in the home. She is with the aunt. And so he would go back to the home, the marital home. If he needed to go to a third location, he would have absolutely no problem with that. I've handled these cases on the prosecution side, on the defense side, special victims unit cases, and I have not seen a man that has done so well after resetting his life and has been so, I guess, adamant about let's do the right thing. He told me, I don't want to run. I don't want to run. The only reason he waited a few days is because we want to make sure he got into court on the appropriate time. He didn't kind of miss work so he can work provides for his family. So he will be subject to any conditions whatsoever that the court would be willing to do. And I think that this, and I don't want to talk too much, Judge. I know that, the court's got a lot of business, but this is a little bit of a unique situation that what comes in the door. And what's concerning to me is how there are so many alternate charges well, not so many, but there's the battery, and then there's the aggravated assault with no weapon recovered. I've seen the injuries themselves or red marks, and the time doesn't make sense. Also, the remarks that were made, and again, this is just complete proffer, Judge. I get that. The remarks that were made to DFACS about how there are too many inconsistencies, warrants weren't taken by the detective, and they just kind of they couldn't walk it back once the road officer, the patrol officer had taken the warrant, so they just kind of left it at that. So I hope that speaks a lot, Judge. But he is a good man, hardworking father. He wants to do the right thing.
So I did see some inconsistencies, and first saying that there's a punch, or the bruising on the arm was a punch, and then the bruising on the arm could have been caused by a metal object. But again, now if the person ran away, and theoretically, if the injury occurred someplace else, there wouldn't be an object recovered at the scene. Okay, this is what I'm going to do. I'm going to grant a $20,000 bond on the aggravated assault charge with a deadly weapon, a $5,000 bond on the battery charge, a $10,000 bond on the cruelty to children in the first degree. There's going to be a stay away provision on the bond, stay away from an Azul is it Espita? Espitia.
Yeah.
There's going to be a preliminary hearing date set for June 27th at 8:30 in the morning, courtroom 201, but most likely it'll be by Zoom. However, if he bonds out, the case will be bound over by operation of law to the Superior Court of Clayton County, and there will be a notice sent in the mail.
Understood, Judge. And would you like me to take an order, or is the court going to present this?
Nope, I've already written it down.
All right, Judge. Well, we appreciate the court's time in hearing us, and that's all the matters that we've got. Rahim, I'm going to speak with your wife, and Your Honor, may we be excused?
Yes, sir. Mr. Keandra Johnson. Mr. Johnson, I'm gonna give you the same speech that I just gave the other gentleman. I would normally speak to you. However, you've taken advantage of the opportunity to hire a lawyer. So I'm going to speak to your lawyer about your case. This proceeding is not private, nor is it privileged. So please don't say anything you wouldn't want the whole world to know. Do you understand that, sir? Thank you. Mr. Clements, your client is charged with 2 counts of aggravated assault with a deadly weapon and 1 count of murder. And of course, I can't set bond at this hearing on the murder charge. So bond is going to be denied pursuant to OCGA 17-6-1. And because I'm denying bond pursuant to statute on that, I'm going to deny bond on the aggravated assault charges and leave the judge that hears this to either set bond or deny bond. Because this is a case that carries life, the Superior Court judges will be the ones who will preside over the bond hearing.
Yeah.
And I don't have that that date. However, I'm going to give you the email address for my judicial assistant. It's Mary, M-A-R-Y, dot.
I wouldn't have the date either. He's gonna have to get in contact with, once it gets, he'll have to get in contact to see who the Superior Court judge is doing. They switch it every month.
Okay. So either, or most likely contact the court administrator in Clayton County and see who is the presiding judge, and you file your motion and they will assign the bond hearing to whatever judge is presiding at that time. And they do it on a monthly basis.
I understand. Yeah, I'll get that. I'm actually going to get that filed today. I'll just bring it over.
Can I say?
Because the case is not in the online system yet, because I tried to file an entry and it's not there yet.
Okay. He's going to have a preliminary hearing date set for June 27th at 8:30 in the morning. And that's going to be by Zoom link. And I think I can tell you right now.
It's you, Judge.
It's going to be me.
Yes.
Oh. Well, it'll be me. So the preliminary hearing will come before me. And just as you at least send an entry in to Miss Mary, so that, hey, can we cut down the crosstalk? Can we cut down the crosstalk on the male side?
Somebody was having a seizure, Judge.
Sorry.
Oh, I understand. I understand. So at least just send your whatever you're gonna file, send it in to Miss Mary, and that's Mary dot.
Judge, I'll send it to him since we're on YouTube.
Okay.
I think I said something. I know I said something over this morning, an entry. It may have been to the lady you're referring to, but I will.
No, I saw it. It went to the receptionist, the secretary up front, and she sent it to me.
Okay. So June 27th at 8:30?
Yes.
All right. And out of curiosity, is it possible for me to obtain a copy of the warrants on these cases before that date?
It is possible. Give me, well, I know we've never met, but I've spoken to you before, Mr. Clements. Give me your contact information.
All right, my email, we can use Kirby, KIRBYESQ, Edward Sam Queen @gmail.com.
Okay. I think you can get one, or you can get the copies, but I'll let you know. Okay.
All right.
Now, do you have any questions, Mr. Clements?
No questions, Your Honor. As I understand it, I'll file the bond motion. We'll find out which judge is going to hear the bond in Superior Court. I'll get that squared away. And the preliminary hearing is set for June 27th at 8:30 in the morning via Zoom.
Yes, sir.
All right.
Okay. Mr. Johnson is free to go back.
All right.
And
I'll come talk to him later after I file all my motions. I'll come talk to him later after that. Thank you.
Okay. Today?
Not today, but I'll try to come today if I'm over there today. All right, bye.
Okay, let's switch over to the lady side. You're free to go, Mr. Clements.
Thank you.
For Miss Martin. Okay, Miss Martin, and I'll tell you the same thing I've told everyone else. You've taken advantage of the opportunity to have a lawyer here. So I'm going to speak to your lawyer directly. I would just admonish you or caution you that anything you say during this proceeding is not privileged or private, nor is it private. So please don't say anything that you wouldn't want everyone to know. Mr. Lewis, I lost you.
Sorry, Judge, hold on.
Okay.
There we go. Is that?
Yes. Okay. So I've set bond on these 3 charges. There's 2 that are traffic related, failure to stop at a stop sign, and there's a child restraint violation. And then there's homicide by vehicle in the 2nd degree as a misdemeanor. Let me ask you this question, Mr. Lewis, because it was unclear in reading the warrant affidavit. Is your client the mother of the child?
She is not, Judge, and that is actually a very good question. My client, and this is the facts as they are undisputed, my client was driving the vehicle. The vehicle belonged to the mother of the infant. The
Okay.
mother was actually in the vehicle next to her infant. She's the one that actually either strapped or failed to strap the child in. They were all involved in the accident. The child was ejected from the vehicle and died.
Okay. Okay. So that helps me. I originally set up a $15,000 bond, but based upon that, on the homicide by vehicle 2nd degree, I'm going to set a $7,500 bond. Because I don't believe your client has a criminal history, if I remember correctly.
That's correct, Judge. No criminal history, 34 years old. We worked closely with the fugitive. We called the fugitive squad because she was out of state at that time. We worked closely with them to get her turned in. She did that promptly, Judge. So thank you, Judge.
Okay. So Miss Mary, is going to be a $500 bond for the stop sign violation, $7,500 bond for homicide by vehicle 2nd degree, and I'm going to leave the child restraint violation at $500 because as I understand the statute, and correct me if I'm wrong, Mr. Lewis, this type of violation, it basically is the driver that gets cited. And so I understand what you're saying as to the mother being there in the backseat, and it may be the mother's responsibility to place a child properly in a child restraint or in a child seat. But as I understand the law, it would be the driver's duty to make sure that everyone is doing what they're supposed to do within the vehicle.
That is correct, sir.
Okay. So I am going to, she's going to have a preliminary hearing date set for June 28th at 8:30 in the morning. And that'll be by Zoom. However, if she bonds out, then that will be waived. I'm not going to place any travel restrictions because it looks like from the warrant, it says that she lives in Connecticut.
She does live in Connecticut, but it's her sister that will be bonding her out, and
Okay.
she will be going back and forth from Smyrna to Connecticut.
Okay. Okay, so I'm not going to place any restrictions on her travel. Just make certain that there's a good address for her to receive notice.
Yes,
So
sir.
there's not an issue of missing a court date. Do you have anything else for me, Mr. Lewis?
No, Judge, thank you.
Okay.
Judge, what date again?
June 28th.
Okay.
These are all misdemeanors. So you're free to go, Mr. Lewis. And Ms. Martin can go back. And then we can get started with the regular calendar.
Thank you.
You're welcome. Okay, let's get started, and I'll read the script, and then we can jump over to the ladies' side.
All right, everybody else stand up.
Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, could everyone please raise your right hand? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Thank you. Let's start with Ms. Blades. Ms. Blades, ma'am, you're charged with one count of disorderly conduct. The bond is set by schedule, which means it's automatically set at $1,500. You're going to have a preliminary hearing date set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you're gonna hire your own lawyer?
No, you can get me a lawyer. I'm sorry, this is my first time.
Okay, it's fine. Just listen to the questions I ask and respond to the questions. You do qualify, ma'am. I'm going to lawyer to represent you. Do you have any questions for me?
Yes, my bond that they gave was 1,800 and something. So you're telling me now that it is 1,500, right?
No, and that's a good question. The bond that I set or that is set, the sheriff's department is required by law to add certain fees to it. And I don't have that fee schedule. They have it. So the number that they gave you is the true and correct number. Okay, any other questions?
So you can't lower it.
No, it's set by schedule. And what that means is that a group of judges sat down and determined this is the appropriate bond for this offense. So I don't go beyond or behind the schedule.
Okay, thank you.
Okay, you're welcome. Let's see, Miss Christian. Miss Christian, ma'am, you're charged with 1 count of criminal damage or criminal trespass, damage to property. This is a misdemeanor offense. The bond is going to be set at $3,000. You're going to have a stay away provision on the bond to stay away from a Roshika trigger. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. Thank you so much.
Okay, have a good day.
Mhm.
Miss Dangerfield,
How you doing?
I'm doing well. Ma'am, you're charged with 1 count of terroristic threats as, let's see, I believe it's as a felony. Yes, it's being charged as a felony. Bond's going to be set at $5,000. There's going to be a stay away provision to stay away from a Aisha Williamson. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for June 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes. Is there any way that the bond could be reduced? I'm not from here. I came here to visit and I, made a mistake threatening somebody at a gas station that I don't know.
Well, the mistake was threatening the person in front of a police officer.
Yes, but she was trying to fight me, so I was just, well, Your Honor,
Yes,
what I
ma'am.
said, Your Honor, what I said wasn't true anyway, because I didn't have anything to, hurt her with.
Well, it's called threat. And so I'm gonna leave it the way that it is. I understand. Problem we have is too many people don't understand how to just walk away.
Yes.
Everybody wants to engage in some kind of fight or something. So I'm gonna leave it the way it is, man.
Okay, thank you.
You're welcome. Ms. Johnson. Ms. Johnson, you're charged with terroristic threats as a misdemeanor. Bond's going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Yolanda Cook. Do you understand that?
No, because I live there and I am a Georgia resident at their home.
So it sounds like you don't like it, but you do understand it.
No, I'm questioning because again, my things are there. And no, I don't. That's why I'm answering the question. What are you talking about? I just answered the question. No, I don't understand that. My stuff is there. I'm a legal resident there. So how you gonna tell me anything else? The officer said last night, I am a legal resident.
Miss Johnson?
My things are there. I'm not leaving my money there. I'm just not. I don't care.
Okay, Miss Johnson. I'm gonna tell you this. You go back over there, you're gonna be charged with aggravated stalking, and you're gonna sit in jail until your trial. The choice is yours. All I have to do is just tell you what is gonna happen. You can do whatever you want to do. You're an adult. If you want to spend
I'm
your time,
supposed to just leave my mail and all my stuff over there?
no. How about asking me a question? How do I get my stuff? How do I get my
That's
mail?
me asking my question.
No, you said, ma'am, you said, so you telling me I got to leave my stuff there? Nope, that is not what I said. Ma'am, this is a court of law. Words mean something. If you're upset with me because you've had to appear before me, I am so sorry. But ma'am, stop. We can have a communication. We can have a conversation. What we're not going to do is have an argument. Do you understand that?
Yes, and that's why I was going to explain to you what my emotions was about before you rudely interrupted me by yelling.
Ma'am, I always ask at the end, do you have any questions? And that's your time to then start speaking. I have to know that you understand this stay away provision, which I'm hearing you do understand, you just are not, you don't like it. I didn't ask you, do you like the stay away provision? I asked, do you understand? It's okay not to like it. That's fine.
I don't understand it. That's what I'm saying.
Okay. So, and I'll explain. Because we don't have the resources to have police officers going out to every house in this county whenever people get into arguments and disputes. When the police are called and a person is arrested and there is an alleged victim, we place a stay away provision on that because, ma'am, you're gonna get out of jail. And what we don't want is whatever argument or dispute led to your coming before me today to flare up again tonight or to flare up again in the morning. And then you're coming back before me. So these conditions can be changed. But right now they're in place, hopefully, so that cooler heads prevail, logic and reason come back in, and you can go about your life. The way that you are triggered right now, I don't know if that's going to happen or not.
Because like 20 people already told me 10 different things, and now you're telling me something completely totally different. It has nothing to do with the actual case. It's what I'm going through after the case. I'm not used to this.
Okay.
I usually go to jail and get out the next day. I'm not used to this. I don't sit in jail. Well, it looks like I'm gonna be sitting here until whatever court date. I don't have any money right now. I'm not used to this.
Well, it sounds like you said you're used to going to jail and getting out the next day.
Yeah.
So you're used to going to jail.
Those privileges right now, that money right now to do that.
Okay, let me finish telling you what I need to tell you, and then we'll pick up this conversation, okay? Your preliminary hearing date is going to be set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to appoint you a lawyer?
Yes.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, Ms. Johnson. The reason you're here is because of the allegation of a threat. That's something that came out of your mouth. Nobody did that to you. So maybe going forward, you don't threaten people, you don't argue with judges, you kind of listen.
Yes, sir.
Okay. Well, you're free to go back, ma'am.
But you just told me I can say my piece at the
Yes, ma'am. I'm sorry. You're right. You're right. Go ahead. You're right.
Okay, so I didn't even know that me saying what I said was even against the law, first of all, because I literally just tried to get help with this same exact thing where somebody literally threatened my life with a whole gun. And y'all literally, and I'm gonna say y'all, because the police officers, the sheriff department told me they could do nothing about it. Now, how am I sitting here? And on top of that, the person that we're talking about literally used to beat me. So how am I sitting here in front of y'all about a threat? How? And I just woke up, so excuse my emotional stuff. I just don't get this at all. I'm used to getting out the next day and going to court. I'm not. And then y'all ain't got no room. Y'all ain't got no room in here. Did you know that? And y'all wonder why I got an attitude. Like, y'all ain't even got no room to put me in here. You trying to keep me in here for a threat? For something I said out my mouth that wasn't really even a threat. It's a it's a barter. If you do that, then my reaction is this. That's not no threat. So now I guess you're just listening to me with no response. I'm just talking to myself. I don't understand what's going on with communication.
I was giving you the respect of allowing you to speak before I spoke.
No, I need an answer on that. Like, I didn't threaten her. I said, if you, then that's what's gonna happen. That means that you have a whole order of steps to go through. Okay, if I go down this line, she's gonna do this. That's not a threat. That's really self-defense. I'm letting you know if you hurt me, I'm gonna hurt you. That's self-defense. That's not a threat.
Okay. Just so we can end this conversation, Ms. Johnson, the allegation was that you threatened to stab her, and it does say that you felt threatened by her. I'm gonna reduce the bond to $1,000. That's $100 through a bonding company. Okay, ma'am, you're free to go back. Let's switch over to the male side.
Next up is Baker. Baker, you're next. Y'all listen up for your names. Y'all be quiet.
Okay, Mr. Is it Ayers or Ayers?
Ayers, yes, sir.
Okay, sir, you're charged with 2 misdemeanor counts of theft. Theft by taking. Bond's going to be set by schedule, which means it's automatically set at $2,000. And bond for the theft by conversion is going to be set at $2,000.
Yes, sir.
You're going to have a preliminary hearing date set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, how much do you make per hour?
$12.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, may you read the bond amount again?
It's $2,000 for each count.
Okay, thank you.
You're welcome. Mr. Baker. Mr. Baker, sir, you're charged with one count of misdemeanor theft by taking. Bond is going to be set at $2,000. One count of terroristic threats as a misdemeanor. Bond is going to be set at $3,000. And one count of theft by shoplifting as a misdemeanor. Bond is going to be set at $2,000. You're going to have a preliminary hearing date set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Bell.
Gary. Next.
Mr. Bell, sir, you're charged with one count of carrying a weapon concealed without a license. The bond is set by schedule, which means it's automatically set at $5,000. This is a misdemeanor offense, so your preliminary hearing date is going to be set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I don't see a form for you. Did you want me to see if you qualify for the appointment of a lawyer?
Yeah, because look, I'm really homeless right now. I ain't got nothing right now. My mom,
Okay,
she
sir,
just got put out.
sir. Yes or no?
Yes, I guess.
I mean, yes, you guess, or
Yes.
thank you. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back. Mr. Berry. Mr. Berry, sir, you're charged with one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. That's a misdemeanor offense. One count of use or possession of drug-related objects. Bond is going to be set at $1,500. And one count of possession of firearm by a convicted felon. Bond is going to be set at $15,000. That's a felony. Your preliminary hearing date is going to be set for June 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir.
Okay, you're free to go back. Mr. Bivens?
Judge, remember, we need to continue him.
Yes. Mr. Bivens? We're going to have to continue your case until tomorrow. Apparently, there are two warrants for the same offense. So you have 4 pending warrants. We're trying to get the officer back in to either recall or dismiss one or the other, so that you have one set of charges going forward. So right now, you have 4 charges, but they're the same charges. So if I were to set bond today, you would still be sitting in jail because you don't have bond set on the other 2.
What you mean the same charges? Like,
You're charged with, sir, stop, please. You asked a question, I will answer your question. You're charged with battery and obstructing an officer. You're charged with that offense in 2 separate ways. Apparently 2 separate officers. One did what we call a WA, which means you come in contact with the person and you arrest them, and one went down to a judge. So you have 4 charges pending, but you can't move forward until 2 are dropped. Okay? So we've reached out to the officer, trying to get the officer back in either today or tomorrow to dismiss either one. It makes no mind to me whether which one they proceed on, but I can't set. If you were here, if I were to set bond today, I would have to set bond on 4 charges. And then you'd be paying twice for the same offense. Does that make sense to you? So we're going to bring you back tomorrow. We're going to have this problem fixed, and then you're going to have bond set on 2 charges. Okay? All right. You're free to go back.
What about the lawyer situation? I'll wait on that.
Yes, but let me ask you this. Do you want me to appoint a lawyer?
Yes, sir.
Okay. Then I'll go ahead and do that. And so I won't have to ask you that tomorrow.
All right.
All right. You're free to go back, sir. Mr. Campbell.
Yes, sir.
Mr. Campbell, sir, you're charged with 1 count of battery and 1 count or simple battery and 1 count of cruel to children in the 1st degree.
Yes, sir.
I'm setting a $5,000 bond on the battery charge and a $15,000 bond on the cruelty to children in the 2nd degree. I'm placing a stay away provision on the bond to stay away from a Sierra Monroe and an Alexis Campbell. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 27th at 8:30 in the morning, courtroom 201, because the cruelty to children in the 1st degree is a felony offense. You didn't fill out the form. Does that mean you're going to hire your own lawyer?
I thought I didn't need one. I want to run something by you real quick.
Well, you can ask the question, but I can't give you legal advice.
Yes, sir. I just wanted to ask a question.
Okay.
So on May 1st, this incident occurred. May 4th, the charges was brought up. May 5th, there was a TPO issued to me. And May 26th, I went to court and everything got dismissed. As far as like everything, I'm trying to figure out where these charges came from as far as the battery and stuff, because I thought they got dismissed May 26th. And 2, do I still need to stay away from Alexis and Sierra because they live with me?
The answer to whether you need to stay away from them, yes. The warrant was taken out on May 4th of 2022. Do you remember your case? You said you went to TPO hearing when?
May 26th, and everything got denied. And to my understanding, that was supposed to be for the battery and for the child domestic, which is why she told me to come up here and get my gun from the sergeant, where I got locked up for the warrants.
Well, I'll check on that, Mr. Campbell.
Yes, sir.
Was there a hearing held?
Yes, sir. I did a virtual Zoom call and spoke with a judge. Me and Sierra was both present, along with, whoever the clerk is for the judge. And the judge denied all like a permanent 12-month thing. And to my understanding, she dismissed everything. That's why I have Alexis for the summer and everything.
Well, the TPO is different from a criminal warrant. So what I'll do is I can go back and look into the system, and I'll find what judge held the hearing, and I'll talk to the judge as to whether these charges should be dismissed or not. And I'll do that after the hearing, but I'll do it today.
Okay, yes, sir. So what do I need to do?
Well, right now you have a bond. And the way it goes is I prepare, you see me moving all this paper around. I prepare everything and I send it back over to the sheriff's department, and that's when they enter everything in. So I'm gonna reach out to the judge and find out the judge's take on it. And if the judge tells me that she thought that everything should have been dismissed, then I'll dismiss it.
Yes, sir, because defects also closed their case 2 days later. So my bond is 5,000 and 15,000.
Right now, yes, sir.
Yes, sir, gotcha.
Okay, you're free to go back.
Thank you.
Mr. Davis, yes, ma'am.
What's his court date?
May 26th.
His court date?
No, well, I'm sorry, ma'am. I'm sorry, Miss Mary. It's June 27th.
Okay.
And I'm gonna check on that TPO thing. Mr. Davis?
Yes, sir.
Sir, you're charged with 1 count of criminal trespass, damage to property. This is a misdemeanor offense. Bond is gonna be set at $4,000. There's gonna be a stay away provision on this bond to stay away from a Brian Bird. Do you understand that?
Yes, sir.
Your preliminary hearing date is gonna be set for June 28th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail, which you need to see if you qualify for the appointment of a lawyer.
All right.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Dudley.
Yes, sir.
Mr. Dudley, sir, you're charged with 1 count of child abandonment. Bond is set by schedule, which means it's automatically set at $1,500. Your preliminary hearing date is going to be set for June 28th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir, but I do have something to say.
Yes, sir.
Back in 2019, I actually went to court and got a judgment. Defects has paperwork on this. I have paperwork on this, as well as the Department of Driver Services, when they released my license from its suspension, has paperwork on this. I just need a chance to bring it up.
Okay, you said you want to.
I have already had judgment on this case. I went to court. I have paperwork. Defects has paperwork, as well as Department of Driver Services when they released my license.
On what date?
On, if I'm not mistaken, it was back in 2019. If I'm not mistaken, the court date was in March of 2019. My driver's license even has its issue date a few days after said court date, because my license was suspended because of it. In my personal effects, I have my license right now.
This is this warrant was taken out on April 17th of 2019. So child abandonment is on a 30-day cycle. So every 30 days. So I would present that information. And if you can show proof, then I think this will most likely go away, but I can't make that determination today.
Good to go. So may I so I can still post my bond and bring back that information?
So I can't have that would be sort of what we call an adversarial situation.
Good to go.
So if it's going to be a trial or a hearing, you got to have both sides present for the trial or the hearing. I can't make a determination with just one side.
Sorry.
And I was asking, did you want me to appoint you a lawyer?
No, sir. I can provide my own.
Okay.
As well, I can even bring up my son's mother. She can tell you she was there.
Okay, so Mr. Dudley, this is a criminal charge. The person that would have to dismiss this is the Solicitor General of Clayton County, because that's the person that's charged with prosecuting. Judges are charged with, if we see probable cause, issue a warrant, have hearings like this, give people lawyers, and the only proper way we can have a hearing is for both sides present. So it would be the mother of the child and you present saying that this didn't happen. Now, the problem may be for the mother is that the mother had to come down and swear that you had not paid.
No, sir, it's not necessarily the fact that it didn't occur. It's the fact that we had already went to court for it and I had already got a judgment for it. I have the paperwork to prove it.
But you said it was in March.
It was 2019. I'm just going off the top of my head as best as I possibly can.
Okay, well, I'm trying to give you the roadmap to what you need to do to get this resolved.
Understood.
Okay, any other questions, Mr. Dudley?
No, Judge.
Okay, you're free to go back.
Thank you, sir.
Mr. Ellison, you're welcome. Mr. Ellison, sir, you've been charged with criminal trespass as being in a place that you're not supposed to be. Bond is going to be set at $1,000. Misdemeanor offense, so the preliminary hearing date is going to be set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sure.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Everett. Good morning, Mr. Everett, sir. You're charged with criminal trespass, damage to property, as a misdemeanor and criminal damage in the second degree as a felony. I'm going to set a $5,000 bond for each offense. There's going to be a stay away provision on this bond, a stay away from a DeAndre Crawford. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay.
What time is that court date?
It's 8:30. But if you bond out, that court date is going to get waived. You do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
So that was trespassing, damage to property for 5,000 with both offenses?
Yes, sir.
Okay.
All right. You're free to go back. Is it Mr. Gaddy Biku? Good morning, sir, or good afternoon. You're charged with one count of theft by taking as a felony. Bond is going to be set at $7,000. Your preliminary hearing date is going to be set for June 27th at 8:30 in the morning, courtroom 203. I'm sorry, 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Hart. Mr. Hart, sir, you're charged with one count of battery against a pregnant female. Bond is going to be set at $10,000. You're charged with obstructing an officer. Bond is going to be set at $2,000. You're charged with the pedestrian in the roadway. Bond is going to be set at $500. And there's also a warrant for your arrest that was issued. Let's see. That was issued on May 7th for criminal damage to property in the second degree. I'm going to deny bond on this charge. It's a felony offense. There's going to be a stay away provision on the bond, a stay away from Brittany Mapp and Raisha Love. Do you understand that?
Yeah, Britt is my baby mom, and Raisha is my sister.
Okay. Your preliminary hearing date is going to be set for June 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Hart. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, sir, you're free to go back.
All right.
Mr. Himes?
Good afternoon, sir.
Good afternoon, Mr. Himes. Sir, you're charged with one count of driving on a suspended license. Bond is going to be set at $1,500. One count of possession with intent to distribute a controlled substance. I'm going to deny bond on that felony offense at this stage. You're charged with one count of violation of Georgia Controlled Substance Act with having 117 grams of marijuana. I'm gonna deny bond on that charge. And you're also charged with use or possession of drug-related objects. I'm gonna set a $1,500 bond. Your preliminary hearing date is gonna be set for June 27th at 8:30 in the morning, courtroom 201. I'm gonna set a
June 27th.
Yes, June 27th at 8:30 in the morning, courtroom 201. Most likely it'll be by Zoom. I'm also going to set a bond hearing date for July 1st at 8:30 in the morning. That's also going to be by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Okay, I only got a number of I got 2 no bonds and 2 1500s, but I got 5 charges.
I only have 4. Hold on one second. What's the 5th charge?
Driving suspended.
Okay. Well, the bond for driving on a suspended license is set by schedule at $1,500. Do you have what we call the warrant number? It should be a 2002 WA.
No, I don't have the warrant number.
Okay.
Just my charges went down.
Okay, well, I'm gonna find the WA number, but suspended license is set by schedule at $1,500. So I'll write that in.
And the reason I have no bond for the 2 felonies is what?
Your criminal history. Let me look again.
I don't have any drug offenses on my criminal history.
Hold on. You have 11 cycles, which means 11 interactions with law enforcement.
But if I have like something that I usually go to jail for and this just came out of the blue, shouldn't I have like the freedom to fight my case from the outside so I can prove my innocence? me sitting in here is I'm gonna lose my job. Like, I'm not going to be able to have a good defense if I sit in here for 2 weeks. I have a job. I'm just trying to get back to my livelihood and fight this case in the best way I know how. All my court cases was dealing with one issue for the most part. And those issues stopped in 2017.
All right, tell you what, I'm gonna set a $10,000 bond on each of those charges. So you're gonna have a $10,000 bond on the possession of marijuana, felony possession of marijuana, and $10,000 bond on possession with intent to distribute.
So is this correct? 2 $10,000 and 2 $1,500?
Will be 3 $1,500 because of the suspended license that you told me about.
I thought that was one of the ones you had already said.
Yes, you're right. I'm sorry. You said you had 5 charges. I asked you what was the 5th charge. You said driving on a suspended license.
They got that. They got the possession with intent, controlled substance, drug-related object.
That's what I have. That's 4.
Oh, well, I thought it was 5. I'm sorry. My apologies.
Okay, so you're gonna have a total bond set at $23,000. Anything else, Mr. Himes?
Did I get accepted for a lawyer?
Yes, you did.
Okay, and so the bond hearing on July 1st, do waive that, like X that out of my paper?
Yes, sir.
In a preliminary hearing for June 27th, if I bond out, that date will change, correct?
That date will get waived. Yes. What'll happen if you bond out, your case will get transferred to the Superior Court of Clayton County. And then when it's assigned a judge, you will get, start getting court notices from that judge.
Okay.
Anything else, Mr. Himes?
No, sir. Thank you for your help.
Okay, you're free to go. Mr. Lay. Sir, you're charged with 1 count of obstructing an officer. Bond is going to be set at $5,000. 1 count of giving a false name, date of birth. Bond is going to be set at $5,000. These are both misdemeanor offenses. You're going to have a preliminary hearing date set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I don't see your form. Do you plan on hiring your own lawyer?
No, I tried to inform for it.
I see it. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back. Mr. Lindsay.
Lindsay told me out of bond, y'all.
He's out on bond?
Yes, y'all.
Okay, thank you. Let's see, who's next? Mr. Miller. Mr. Miller, sir, you're charged with 1 count of criminal trespass bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Keandra Gray. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. I see you did not fill out the application for appointed counsel. You're going to hire your own lawyer?
No,
So you're going to represent yourself?
no. No, 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 sir.
Okay. Is there a reason you didn't fill out the form?
No. Do I need a lawyer for that, or a public defender?
You're entitled to one if you qualify. You also have the right to refuse one. That's why I asked the question.
I refuse.
So I need to understand what you want to do.
I refuse it. I refuse the counsel.
Okay. Do you have any questions for me?
No.
Okay, sir, you're free to go back. Mr. Mormon.
Afternoon, sir.
Good afternoon. Do you know what you're charged with, Mr. Mormon?
Yes, well, I heard what they told me, yes.
Okay. I can't set a bond for this offense by statute at this stage. So bond is going to be denied pursuant to OCGA 17-6-1.
Can you repeat that? OCGA
OCGA 17-6-1.
Okay. I'm sorry, go ahead.
I'm sorry.
No, there hasn't been like an investigation or anything. Like, is there any type of way I could be able to get bonds so I can get a lawyer to be able to represent me, so that way I can be able to get this case handled?
Well, I just gave you the statute that says I can't set bond at this stage. Doesn't mean you can't get bond. It just means I can't set bond.
Understand.
Your preliminary hearing date is going to be set for June 27th at 8:30 in the morning, courtroom 201. You're going to have a bond hearing set for July 1st at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify. I'm going to appoint a lawyer to represent you. Now, the way that this charge is written, they actually charge you under the wrong subsection of that statute. They have what they call a Jack and Jill provision, where people are close in age and they're teenagers, but you're not a teenager. So I suspect that these charges will be changed, or the statute will be changed, but the same charges will be there. Do you have any questions for me?
No questions.
Okay, sir, you're free to go back. You're welcome. Mr. Phillips. Mr. Phillips, sir, you've been charged with a number of offenses, some misdemeanors, some felonies. You're charged with one count of simple battery. Bond is going to be set at $5,000. You're charged with one count of criminal damage to property in the second degree. Bond is going to be set at $5,000. You're charged with one count of misdemeanor theft by taking. Bond is going to be set at $2,000. You're charged with one count of aggravated assault. Bond is going to be denied at this stage. You're charged with one count of obstructing an officer. Bond is going to be set at $5,000. You're charged with one count of fleeing from a police officer. Bond is going to be set at $5,000. 1 count of reckless driving, bond is going to be set at $1,500. 1 count of driving on a suspended license, bond is going to be set at $1,500. 1 count of theft by receiving stolen property, bond is going to be set at $2,000. 1 count of possession of firearm during the commission of a crime, bond is going to be set at, bond is going to be denied on that account. And 1 count of aggravated assault by strangulation, bond is going to be denied. You're going to have a preliminary hearing date set for June 27th at 8:30 in the morning in courtroom 201. That most likely is going to be by Zoom. You're also going to have a bond hearing date set for July 1st at 8:30 in the morning, which again, most likely will be by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, Mr. Phillips. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yeah, there's no way I can get a bond for the rest of those charges I got denied for.
No, sir. Do you have any more questions?
No, sir.
Okay, you're free to go back. Mr. Presley.
Yes, sir.
Mr. Presley, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $1,500. This is a misdemeanor offense. So you're going to have a preliminary hearing date set for June 28th at 8:30 in the morning, courtroom 201. But a date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond, also to stay away from a Lindsay Garrett. Do you understand that?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Presley. Mr. Robinson.
Hello, Judge.
Hello, Mr. Robinson. Sir, you're charged with a number of offenses. And some of these I cannot set bond for at this stage. You're charged with 1 count of assault with intent to commit a crime. Bond is going to be denied. That's a felony offense. You're charged with armed robbery. That's also a felony offense, and I cannot set bond pursuant to statute 17-6-1. You're charged with possession of a firearm by a convicted felon. Bond's going to be denied. You're charged with possession of a firearm during the commission of a crime. Bond is going to be denied. You're charged with reckless conduct. Bond is going to be set at $1,500. You're charged with possession of firearm or weapon during the commission of a crime. Bond is going to be denied. And you're also charged with the second offense of use of a firearm by a convicted felon during the commission of a crime. Bond is going to be denied. You're going to have a preliminary hearing date set for June. Where is that going? I'm sorry, June 27th at 8:30 in the morning. Because the armed robbery offense carries a potential life charge, I can't give you a bond hearing date yet. That has to be set with whatever judge is going to be presiding that week, Superior Court judge. So any offense that may carry a life sentence, Superior Court judges are the ones that sit for bond hearings. So you will receive that notice. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you, it says you're working. How much do you make per hour?
15 an hour.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, why most of my charges, I'm being charged with two of the same charges?
So since July 1st, they have broken it down to if you find multiple firearms, then you have to charge each firearm.
Wait, so if you telling me there was multiple firearms found?
Okay, hold on one second. Black Springfield 45 caliber gun. And let me see. Okay, so there are two locations, International Discount Mall and Cash America Pawn. So each incident carries its own set of facts.
Yeah, but that doesn't make no sense to me. I haven't committed those crimes.
I understand you're an innocent man as you stand here. That's why we appoint lawyers. But this conversation needs to be had with your lawyer, because your lawyer is the person that can investigate the facts and bring that information to a judge.
When will I be able to see my lawyer?
You're going to be appointed a lawyer today.
Okay.
As I tell people, I don't work for the public defender's office, so I can't say when it's going to happen. I do know the way that they communicate is once they get this form, which they will get today, they will set up a meeting over the little TV portal or whatever it is, so that they can at least start speaking to you and start finding out information so that they can then start investigating. Okay.
So
all right.
Court date?
June 27th. That's a Monday. Okay, sir, you're free to go back.
Thank you, Judge.
You're welcome. Mr. Saul?
Yes, sir.
Mr. Saul, so you're charged with one count of essentially being on a public transit without paying the fare. I've set the bond at $1,000. You're going to have a preliminary hearing date set for June 28th at 8:30 in the morning. That date will get waived upon your ability to bond out. I see that you refused to fill out the form. Does that mean you're going to represent yourself?
I don't need no attorney. I shouldn't have a charge because the fees were paid on that.
Okay.
Train.
Do you have any questions for me?
Nope.
Okay, sir, you're free to go back. Mr. William.
Yes, sir.
Sir, you're charged with one count of battery. Bond is going to be set at $5,000. There's going to be a stay away provision on the bond to stay away from a Patricia Milam. Do you understand that?
Yes, sir. Why so high though, sir?
That's the bond. If you've been listening, that's the bond I set on every battery.
Oh, okay. Yes,
Okay.
sir. Yes, sir.
And the basis for it is that I believe adults have the capacity to keep their hands to themselves. And if that's the allegation, then I set the bond.
I was hit first, sir, but I know this ain't the time for that, but I was hit first.
Right.
Yes, sir. And they weren't locked up like me, and I was hit first with a plate.
It's you know, I won't comment.
Yes, sir.
Your preliminary hearing date is going to be set for June 28th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. William. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, sir.
Okay.
So they're gonna be about 500 through a bond to come?
Yes, sir.
Okay. Yes, sir.
Okay, you're free to go back.
Yes, sir.
All right. Is Mr. Wyatt OTB?
Yes, Your Honor.
Okay, we have made it to the end.